So it's true that the court only struck down Section 4 and not Section 5, but I think there are some signals in the opinion, the majority opinion, about the court's attitude to Section 5 that we should talk about. The court, whether we like it or not, the majority thinks of Section 5 as constitutionally problematic. They're willing to tolerate it. They said it was justified in Katzenbach, but I think they put it in a separate constitutional status than what they see as conventional remedies. They keep citing Katzenbach for the proposition that it's an extraordinary remedy that kind of needs some special justification. And what I take that to mean is that there can't, in the court's mind, there cannot be a permanent preclearance regime. As a constitutional matter, preclearance has its own sunset, even if Congress didn't put a sunset in it. And that means that as a constitutional matter, the coverage formula or the necessity of a preclearance regime has to have some renewal. Now, they don't specify as a matter of constitutional doctrine whether that's a decade, 2 decades, or whatever, but something like that has to happen. And I think, you know, one of the most significant lines in the opinion, I think, is the court's statement that if Congress had used this coverage formula as its first iteration of how to do preclearance, it wouldn't have passed the same rationality test. And by the way, picking up on Sam's point, you know, I think they just wanted to deflect the Bernie issue. Bernie is such a much tougher test of Section 5 power under the 14th Amendment or Section 2 power under the 15th Amendment that, and since it was a tougher test than the original Katzenbach test itself and the earlier 1960s view of Section 5 power, that the court, since it found that it could strike it down under the more lenient test, they just didn't want to go to the more difficult test. But I guess my basic point then is that if the voting rights community, or as a policy matter, we think that there ought to be a permanent preclearance regime, I think we have to look elsewhere, and perhaps we can look to the Arizona case. If preclearance were limited to federal elections and not state elections. In other words, it seems to me that going forward, and I know this is this afternoon's conversation, but if we want a preclearance regime justified under the 14th and 15th Amendments, there needs to be a new coverage formula, and that may be difficult, and we could talk about how to go about doing it. But I think it would be necessary to recognize that that would not be a permanent regime. It has this constitutional sunsetting feature as long as the present 5-member majority of the court exists. If the policy recommendation is that elections need a permanent preclearance feature that doesn't have to be constantly rejustified, maybe Congress has the power under the Elections Clause to impose that kind of regime for federal elections exclusively. Now, as a practical matter, state elections and local elections may be swept under because it's just so difficult for states to have 2 different electoral systems. But I think if the goal is something like that the way in which elections should be run is that all states or some number of states have to submit for prior approval, that we should look to the Elections Clause instead of the 14th and 15th Amendment perhaps to justify that.